Welcome to the deep dive. Today we are wrestling with one of the most significant and, let's face it, contentious issues in the U.S. gun laws.
Yeah, really complex topic.
Definitely. Specifically, we're going to unpack the intense debate around assault weapons, high-capacity magazines, and, how it all ties back to the Second Amendment.
And for this deep dive, we've pulled together quite a range of sources. We're looking at policy reports, think organizations like Everytown, legal analyses from places like the Brennan Center,
Okay.
plus public opinion data from Pew Research, and then really digging into the history of the Second Amendment itself and those landmark court cases using legal scholarship and historical commentary.
Right. So our mission here is to take the stack of information, try to cut through the noise, and help you understand the core facts, the different viewpoints, and where things stand legally right now, especially because there's been some really pivotal Supreme Court action recently. It's about getting you informed quickly but thoroughly.
And what's really fascinating, I think, is how the current legal landscape isn't just evolving. It feels like there's been a fundamental shift.
Okay, let's unpack that. Because you're right, the whole framework for how courts look at gun laws, it changed pretty dramatically not too long ago.
Absolutely. The key moment was the Supreme Court's Bruen decision, June 2022. Before Bruen, courts mostly used this kind of two-step process.
Right, I remember that. Step 1 was about the core, right? And step 2 was scrutiny.
Exactly. Intermediate scrutiny, usually. Basically balancing the government's interest, like public safety, against the individual's Second Amendment right.
But Bruen just threw that out.
Pretty much.
Yeah.
Bruen set up a whole new test. The government now has to show that any gun regulation is, and this is the key phrase, consistent with the nation's historical tradition of firearm regulation.
Text and history. So history is now the main event.
It is the main event. No more balancing. History is the primary battleground in these court cases now.
So the big insight here is that one Supreme Court decision didn't just tweak the rules. It basically rewrote the entire plea book, turned legal fights into historical debates.
That's a great way to put it.
Yeah.
And our sources, they show this has just unleashed this, unprecedented wave of lawsuits challenging existing gun laws all over the country.
Including the ones we're focusing on. Assault weapons, high-capacity magazines.
Yes, absolutely. Those are right in the crosshairs.
So how are the courts handling this? I mean, suddenly being asked to be historians.
Well, it's a huge challenge. The sources make that clear. Courts are openly, grappling with how to apply this historical test. Interestingly, 4 different appellate courts have actually rejected challenges to state assault weapon or high-capacity magazine bans since Bruen.
Okay, so they upheld the bans.
They did. But here's the twist. They didn't all agree on how they got to that conclusion based on Bruen.
Okay, same outcome, different reasoning? How does that work?
Well, some courts focus on step 1, sort of asking if things like assault weapons or high-capacity magazines or even protected arms under the Second Amendment, historically speaking. Were things like that common back then?
Okay, so maybe they're not covered by the Second Amendment at all.
That's one line of argument some courts took. Others kind of skipped that or interpreted it differently and went straight to looking for historical analogs, trying to find similar regulations from the 18th or 19th century.
Huh. Sounds messy.
It is. It's complex, and Justice Breyer actually predicted this in his Bruen dissent, saying, judges aren't historians. One federal court even talked about maybe needing to appoint a historian for a case.
Wow. That really shows you the level of disruption. And we're seeing this split in lower court rulings too, right? The sources mention some laws being upheld.
Yeah, exactly. Like federal laws about commercial gun sales were upheld in United States v. Talata. The court there said the challenger has the burden to show the Second Amendment is even involved. And Florida's law setting a minimum age to buy guns, that was upheld in NRA v. Bondi based on historical age restrictions.
But then other laws are getting struck down.
Right. On the flip side, you have cases like United States v. Crossroads. There, a law stopping people under indictment for a felony from having guns was struck down. The court basically said Bruen's history test was an almost insurmountable hurdle for the government.
Okay.
And maybe even more controversially, a panel in the Fifth Circuit in United States v. Rahimi struck down the federal law that prevents people under domestic violence restraining orders from having guns.
Whoa. That law seemed pretty settled. How did they justify that historically?
They used a very specific reading of the history looking for an exact match, which one source called outrageous, and an unduly narrow application of Bruen. It really highlights the uncertainty.
Yeah, striking down laws aimed at domestic abusers. That feels like a major shift. Which it brings up a big question. If lower courts are struggling and getting different results, what's the Supreme Court doing about all this?
Okay, so that leads us right up to June 2nd, 2025. Very recent. Our sources cover this. The Supreme Court announced it would not hear challenges to two specific state laws. Maryland's assault weapons ban.
Snope v. Brown, right?
That's the one. And Rhode Island's ban on high-capacity magazines, Ocean State Tactical v. Rhode Island.
Okay, so they didn't take the cases this time. Does that mean those bans are safe? Or that the court agrees with the lower courts that upheld them?
Not necessarily. The court declining to hear a case, it doesn't set a precedent or mean they approve of the lower court's logic. But here's the really crucial part. Justices Kavanaugh and Thomas, they wrote separately.
Ah, okay. What did they say?
They basically voiced concerns about how the lower courts are applying the Bruin history test in these cases. And they pretty explicitly signaled that the Supreme Court will likely need to step in and address the constitutionality of assault weapons bans specifically just later.
So it's not over. They just kicked the can down the road a bit, but signaled they will tackle it eventually.
Exactly. It suggests the issue is very much alive and far from settled at the highest level. Expect more legal battles.
Okay, so I've got the Second Amendment, the Bruin earthquake, changing the rules, courts scrambling, the Supreme Court watching. Let's circle back to the specific items at the heart of this. Assault weapons and high-capacity magazines. What exactly are we talking about and why the focus?
Right. So high-capacity magazines, or HCMs, sources like Everytown typically define those as magazines holding more than 10 rounds of ammunition.
More than 10. Got it.
And assault weapons.
Yeah.
Well, that term itself is debated, but it generally refers to semi-automatic firearms, often rifles, that have features originally designed for military use. Think high-powered rounds, high muzzle velocity.
And they fire quickly.
They can, especially when paired with those high-capacity magazines. That combination allows for a high rate of fire.
And the sources, they draw a pretty direct line between these specific types of firearms and accessories and mass casualty events, right?
Yes, the data presented is stark. Everytown, for example, points out that the 5 deadliest mass shootings over a recent decade all involved assault weapons and HCMs.
All 5.
Yeah. And their analysis, looking at shootings between 2009 and 2017, found that when HCMs were used, the incidents resulted in, on average, twice as many deaths and 14 times as many injuries.
14 times the injuries. Wow, that number just jumps out.
It really does.
Sure.
They also mentioned the Fort Hood shooter specifically requested high-capacity magazines before his attack. This kind of data is central to the arguments for restricting them.
Right, and those arguments basically are that restrictions help prevent mass shootings and maybe even reduce daily gun violence. Exactly. The Everytown research suggests states with bans on large-capacity magazines experience mass shootings at less than half the rate of states without such bans. They even quote a researcher, Dr. Michael Siegel.
What did he say?
He said, basically, that whether a state has a large-capacity magazine ban is the single best predictor of the mass shooting rates in that state.
The single best predictor. That's a strong claim.
It is. And there's also a mention of a study looking back at the federal assault weapons ban that was in place from 1994 to 2004. That study linked the ban to a 70% lower chance of dying in a mass shooting during that period. So these are the core public safety arguments you see from groups advocating for restrictions.
Okay, so you have the legal chaos from Bruin, the specific concerns about these weapons based on data. Now, let's layer in public opinion. Pew Research data shows about a third of U.S. adults own guns, right?
That's around a third. And overall, a majority, 58%, say they favor stricter gun laws in general.
But, and this is probably no surprise, it gets complicated when you look closer. Extremely complicated. The partisan divides are just massive. While most people agree on some things, like preventing people with mental illness from buying guns or maybe raising the purchase age to 21.
Yeah, those seem to have broad support.
They do. But when you ask about banning assault weapons and high-capacity magazines, huge split. 85% of Democrats say yes, ban them. But about 55% of Republicans say no, oppose the bans.
That's a chasm. And it goes beyond just bans, doesn't it?
Oh, yeah. Look at policies like allowing teachers or school staff to carry guns. 74% of Republicans support that. Democrats, largely opposed. Same with concealed carry in more places. 71% of Republicans support it. Most Democrats don't.
And it's not just party, right? Pew shows a split on the fundamental question of whether guns make us safer.
Exactly. Americans overall are almost evenly split. 51% say it's more important to protect gun rights. 48% say control gun ownership. And on safety, 81% of Republicans think gun ownership increases safety. But 74% of Democrats think it reduces safety.
81 versus 74.
And geography matters too. 64% of people in rural areas say more guns mean more safety, while 57% in urban areas say more guns mean less safety.
So these deep, deep divides in public opinion, they're basically mirrored in the legal faiths we're seeing. Advocacy groups on both sides pushing their interpretations.
Absolutely. Groups like the NRA, Gun Owners of America, CCR-KBA pushing the rights-based historical arguments, versus groups like Brady or Everytown focusing on the public safety data and arguing for regulation.
And it loops back to Bruin. Professor Daryl Miller's point, mentioned in one source, seems really relevant here. He warns that if Bruin's text and history test is the only thing that matters, it could put a lot of long-standing gun laws up for grabs. Even things like prohibiting felons from having guns or banning guns in sensitive places like schools or government buildings. Is that right?
Yeah, it's the concern raised, yes.
Yeah.
If you can't find a direct historical analog from the 18th or 19th century, is the modern law suddenly unconstitutional? That's the big question Bruin introduced.
So summing this up, the sources really paint a picture of this core tension, don't they?
They really do. On one side, you have strong policy arguments, backed by data, for restricting certain firearms, particularly those used frequently in mass violence. On the other side, you have powerful constitutional arguments rooted in the Second Amendment, its text, its history.
Especially as interpreted by the Supreme Court in Heller, McDonald, and now, crucially, Bruin.
Exactly. And it's all playing out right now in this rapidly changing legal landscape post-Bruin.
Yeah, it's clear that while the Supreme Court affirmed an individual right to bear arms back in Heller, the actual boundaries of that right today, what it means for modern firearms, for things like assault weapons and HCMs and the regulations targeting them, that's still being intensely fought over.
And decided, sometimes inconsistently, by courts all across the country. The Supreme Court's recent decision not to jump in yet on those state bans doesn't really settle anything. If anything, it just sets the stage for the next round.
It really does.
So maybe final thought for you, the listener, to mull over. We've seen how dramatically the legal rules have changed with Bruin. We see the deep divisions in public opinion. We see courts struggling with history. So how will the courts, and ultimately the Supreme Court, draw that line? How will they navigate between protecting the right to bear arms as they see it historically and addressing these very modern, very real concerns about public safety in the 21st century? Where does that balance end up?